Yes. You know, they say that talk is cheap until you hire a lawyer. The topic of my speech today is, so you want to file a lawsuit. Nothing in my talk today will be a fabrication, I promise you. I have clients who come into me all the time and they say, I want to sue so-and-so. I want to do this. I want to go to court. And I say, so you want to file a lawsuit? Let me tell you why you might want to reconsider. My personal bias is that filing a lawsuit and taking things through the court is probably the least effective way to solve problems, and I'll tell you why. And then I'll tell you what my alternatives are to a lawsuit. Let's start with the cost. And I've done probably hundreds and hundreds of litigations, mediations and arbitrations, but I'm just focusing on lawsuits right now. The cost of filing a lawsuit from what I call soup to nuts, which is filing the complaint through the trial, is approximately $50,000 to $75,000. And that's at the low end. It can go much, much higher than that, depending on how complicated the case is and how many people are involved. Now, that doesn't include expert witnesses. When you get into litigation, oftentimes you need expert witnesses because you have to prove a point that only an expert can give an opinion on. Expert witnesses usually charge somewhere in the neighborhood of $500 to $1,000 an hour. I thought there was only one other profession that charged that much, but expert witnesses will be in the $500 to $1,000 range. What do they have to do for that? Well, they have to understand what the case is about in order to give an opinion. They'll probably have their deposition taken, and they will probably testify at trial. I say probably because sometimes you interview witnesses, expert witnesses, and sometimes you use them, sometimes you don't. So from a cost standpoint, you're spending a lot of money to do what I call peeking under the tent to see if you could win your case. The other problem is time. People usually come in and they want to file a lawsuit and they're really angry about something. Well, guess what? It's going to take you at least, in Santa Clara County, 2 years to get to trial. Could be as much as 3 or 4. I've seen them as long as 5, but 2 years is probably an average. Could you get to trial sooner than 2 years? Possible. But usually it's a 2-year period, which is a long period of time. A lot of that anger has dissipated over that 2-year period. So you're thinking, well, $50,000 to $75,000 in 2 years. Why does it take that kind of money and that kind of time? I'll tell you. When you file the lawsuit, you get what I call the varnished truth from your client. I say varnished. Your client comes in and your client tells you his or her story. Okay, that may or may not be the truth, because the client wants you to believe, and they do, what the client says. This is the way it's going to work. This is what happened to me. Here are the documents. You don't really know the true story in a lawsuit until you do the magic word discovery. What is discovery? I have to know everything that the other side knows, and the other side needs to know everything that I know in order to prosecute your case. We've all seen the TV shows, and you probably have a favorite movie about lawyers. It doesn't work that way. Nothing happens in an hour. Nothing happens in an hour and a half for a movie. My favorite movie is My Cousin Vinny, by the way, which I think is hilarious. It has nothing to do with what really goes on in the court of law, but it is fun. So you're doing discovery. How does discovery work? Well, it can take many kinds of forms. One is interrogatories, which is a lawyer fancy word for questions. Formal questions that have to be answered formally by the other side. They're tedious and time-consuming. I downloaded that many of the interrogatories, form interrogatories, special interrogatories this morning before I came over here. It takes hours and hours and hours to weed through that. Another form of discovery is a request for production of documents. You give me every document you have. You can't tell me that the documents aren't relative or you don't want to give them to me. You have to give me all the documents. The judge will decide whether the document is relevant or not and whether it gets admitted at trial. Conversely, I have to do the same thing on my end. I have asked for a request for production of documents and had somebody come in with with one of these hand trucks with 4 banker's boxes of documents. Think of what it takes to assemble that, get it organized, and make sense out of it. It takes quite a long time. So that's where your $50,000 to $75,000 is starting to ramp up. The third thing that you do in discovery is depositions. These are also very time consuming. A deposition is a series of questions asked to a party or a witness or an expert witness under oath before a court reporter. Now, in order to do a good deposition, I mean a carefully thought out deposition where you really get at the heart of the case, you have to prepare. I mean, I've never seen anybody be able to just wing it, walk in and just start asking questions and do a really good job. You got to prepare. You got to prepare your questions, you got to prepare your documents, and then you got to take the deposition, and the court reporter, when they're finished, will give you a booklet showing you the deposition transcript, which will be every question I ask, every answer that's given, all the interchange between the lawyers, all in that booklet. You then have to go and review that deposition transcript with your client to make sure your client doesn't say to you, well, I didn't really mean to say that. You can change it, that's fine. So all of that takes time. The 2 things that I want you to consider is during the pendency of the trial, the court is going to make you do 2 things. One is they're going to send you to ADR, which is Alternative Dispute Resolution. That means you either go to mediation, non-binding arbitration, or some mechanism where an independent third party can try to resolve your case for you. Number 2, before you get a courtroom for that trial, you have to do a trial settlement conference. On the eve of trial, you go try to settle your case in a trial settlement conference. Here's my thought. You're doing all of this, and toward the end, the court shoves you out into a mechanism that tries to get you to resolve your case. Why not do that up front? Why not try to mediate or resolve it informally between the attorneys before you spend the $50,000 to $75,000? I think that makes a lot of sense. That's what I urge my clients to do, because you're not going to be happy when you spend that kind of money, because even if you win, you might not be able to get your attorney's fees back. So you're chasing, and what I always say to people, how much money are we chasing here? If you're chasing 50, and it's going to cost you 30 to 40 to chase it, does that make any sense? Would you go to Las Vegas and put your money down on red on a roulette table in the hopes that you'd get maybe $10,000 more, but you could lose the $40,000? You'd be crazy. And that's what litigation is all about. So I say go to mediation, go to an ADR process, and avoid going through the entire